So Justice Leonen and then Justice Velasco.
Good afternoon, Counsel.
Good afternoon, Justice.
And with the indulgence of my other colleagues, may I proceed to ask questions from you?
Yes, Your Honor.
To clarify some of our ambiguity
Yes,
with
Your
respect to our positions in respect to, I think, 15 petitions and 4 comments in intervention. But first, let me just comment on the opening statement made by the Senator. We thank him for that because at least he has given us a bird's eye view of what we are to expect this afternoon, maybe until the early evening, regarding the arguments of the petitioners. It's quintessentially Senator Tatad, and I know him, and his manner of style, so to speak. May I know first if you prepared your petition yourself?
Yes, Your Honor.
Yes, and let me just go through the technical issues a little bit. This is in relation to the advisory subparagraph B in terms of your presentation because I felt you didn't have time to adequately cover it. But maybe just a few questions that will guide you. Your petition, is it a Rule 65 petition?
Yes, Your Honor.
So is it in the nature of certiorari or prohibition?
In our personal, in the petition of
Yes.
Alliance for the Family,
Yes.
we just captioned it as prohibition, Your Honor.
Thank you. You know, of course, that in prohibition, that there are certain acts that will only be covered by an action, a special civil action for prohibition, correct?
Yes, Your Honor.
For instance, that a quasi-judicial or judicial decision has been made, correct?
Yes, Your Honor.
Or that a ministerial act has also been made. Is that not correct?
Yes, Your Honor.
Yes. Has there been a decision in a court of law, a quasi-judicial decision, maybe by the FDA or the listing on the national formulary of drugs, or a ministerial decision on the part of the Office of the President, maybe a police out there that has caught somebody who may be a conscientious objector, etc.?
Yes, I'm representing all the petitioners, Your Honor, and the petitioners have filed a petition for certiorari prohibition, Your Honor. So in effect, we're also saying is that there's an exercise here there's an allegation of grave abuse of discretion amounting to lack or excess of jurisdiction
Yes, that's
in
one of
coming
the
up with the RH law.
Yes,
Your
that's
Honor.
one of the requirements. We know as lawyers that because we are not a council of the faith, nor are we medical doctors, what we can only do is act as the High Court, the Supreme Court of law in this country.
Yes, Your
so
Honor.
therefore, all we can use as our tools would be the law and the legal issues as properly framed in this case. So I beg your indulgence. So yes, that's a requirement, that there is a grave abuse of discretion. Perhaps that is properly alleged, and I concede that for now because it's not part of the advisory. The question, however, is the other parts, the other elements. You have to comply with several elements, not only one. Just because you comply with grave abuse of discretion doesn't mean that we can act on your petition immediately. Later, we will see why, perhaps through a question and answer format. But then in terms of whether you have succeeded in raising the ministerial act that you want to prohibit, may I know what the ministerial act is that you are wishing to prohibit?
If Your Honor, please, when we when we question the constitutionality of a law, Your Honor, it is usually done via Rule 65, certiorari and prohibition, Your Honor. And this has been liberally construed and allowed by the Supreme Court, Your Honor, in various cases.
I am not sure about that. That this court is now wanting to act as a political tribunal that will want to shunt aside many of the precedents that we have in relation to constitutional litigation. But let me proceed. For instance, we have this presumption of constitutionality. Is that
yes,
not
Your
correct?
Honor.
Are there cases where the presumption is not of constitutionality? In any case, that means that if there is a doubt with respect to the ambiguity of the provisions, that there may be provisions which will say abortifacient, non-abortifacient, that our standpoint, our viewpoint, should be to be faithful to our precedents and the foundation of this court in the constitutional order, that we should always accord a presumption of constitutionality.
I agree with you, Your
So
Honor.
maybe we can have that as an agreement that we have to accord this law a presumption of constitutionality. Counsel, may I know why? Do we have to accord it? Why is there such a doctrine of presumption of constitutionality?
Well, we have to presume that official acts have been done properly and correctly, and there's that presumption that official acts have been done. Have been legally performed, Your Honor.
And to be fair, are there exceptions to the presumption of constitutionality? Are there any exceptions in our doctrines insofar as the jurisprudence of the Republic of the Philippines is concerned with respect to the presumption of constitutionality? Is there a situation where we can presume unconstitutionality at the get-go?
I am not aware of any presumption of unconstitutionality, Your Honor.
To be fair, I think it was raised by your third speaker, Atty. Liban, who will speak on freedom of expression. And this is when you can show us very clearly that there is such an effect. And I think it is content-based and a prior restraint at that. But we will await his
I
presentation.
recognize that, Your Honor.
But to our recollection, there is no reverse presumption in cases of equal protection of the law. Is that not correct? It is the petitioner that will discharge the burden of clearly showing in fact and in law that there is such a violation, a clear, undeniable violation of the Constitution. No such presumption in equal protection of the law challenges. Doctrinally,
Yes, Your Honor.
would you know of any? Because maybe our research is not that clear. Are we not correct that so far we do not have that doctrine? It is always a presumption of constitutionality. Yes. What about due process? Is there a reverse presumption? None. Also, I don't know if I'm mistaken. The due process clause reads, "No person shall be deprived of life, liberty, or property without due process of law." It is one clause.
Yes.
And the due process, therefore, embeds in it the concept of the right to life, which means, therefore, that our standing doctrine is that there is a presumption of constitutionality of the act of a political department here, two political departments. And my hat's off to all your advocates here, because you have stood your ground for 13 years in the political departments and had a vote publicly done on televised nationwide. I remember that night because I had to stay up because I was riveted by the debates. Some disappointing, some inspiring, and it was drama that was happening, yes. So that was a political decision made by another department. So the right to life, therefore, there is no presumption yet of unconstitutionality. Am I not correct?
If Your Honor, please, right to life, as I said, is the most fundamental among all rights.
I agree.
It may even precede humanity. It precedes
agree.
all institutions, Your Honor.
I agree.
So, if Your Honor, please, while there may be a presumption of constitutionality insofar as the
I
right to life, this will have to be looked into very carefully, Your Honor, by no less than the guardians of the Constitution, which is
I agree.
yourself, Your Honor,
because we are-
and the rest.
Yes, because we are the guardians of the Constitution, we have to be very clear about our signals to the public in relation to when a political act made by democratic organs are going to be vetoed by us. And therefore, that's why I have to go through these technical issues very clearly, just to satisfy my conscience and myself that I sit here not in political judgment, but in legal judgment. So bear with me a little bit more.
Yes, Your Honor.
Yes, it's fundamental, and I guess I could concede to you that all of us, because we took an oath to the Constitution, agree that the unborn is protected from conception. But you will also agree with me that the Constitution does not mention when conception happens. Is that not correct?
The Constitution itself, Your Honor, but if something is not, if we want to really know the meaning and the intent of a constitutional provision, then of course we have to go and to go into finding out that intent, and that should be available in the records of the Constitutional Commission, which I
In fact,
pointed
there
out
are
earlier.
decisions of this court, unanimous on the part of the en banc. Civil Liberties Union versus Executive Secretary. The interpretation of the court shall be made by this court. It shall not be made by the Constitutional Commission. We get advice from them in terms of their deliberations, but the deliberations are not all. And from one of my mentors here, Justice Peralta, I think he already gave you the clue that when people ratify the Constitution, they did not read the proceedings. They read the words. It said conception. And therefore, to a certain extent, there is some contemporariness in terms of our interpretation. Is that not correct?
There must be a presumption that the people knew what they were ratifying. And I will not be surprised, Your Honor. I was already in college probably at that time. And then there were a lot of discussions about certain provisions of the Constitution. And this must be one of those that was
And the people
extensively
were
discussed.
presented with the words conception, not fertilized ovum. Is that not correct?
Pardon, Your Honor?
And the people were presented with the words in Article 2, Section 14.
Section 12?
Section 12, I'm sorry. Conception, not fertilized ovum. Is that not correct?
Conception and fertilization. And when you talk of
Indeed.
fertilization, you cannot but also think of
I'm sorry,
the
but
fertilized ovum.
the copy of my Constitution might be wrong. It did say conception, correct? Not fertilized ovum.
Yes,
So
Your
it left
Honor.
it to a court of law at the proper time with the relevant issue to actually determine when conception happens. Is that not correct?
How is that again, Your Honor?
So it left it, the Constitutional Commission and the people exercising their sovereign rights to enact a constitution to a court of law to determine at some future time with a relevant legal issue to determine when conception happens. Is that not correct?
I beg to disagree, Your Honor. I think that conception is a clear, has been defined by the Constitutional Commission, and there is no need for that
Nonetheless,
activity, Your Honor.
as your response to Justice Carpio, all of them my mentors, Justice Carpio now said, we are being asked by you, and you agreed, to determine the beginning of life, when life begins. And isn't that an awesome responsibility given to such secular individuals? 15 of us, not the 24 senators who were elected with millions of votes, not the 200 plus members of the House of Representatives, not the two of them acting together, not a president elected by popular vote, but you give it to us, who took an oath to read the Constitution very carefully, with the provisions of Article 6 and Article 7, which creates the executive and the legislature to determine the beginning of life.
If Your Honor, please, I think it is also an inherent, a bounden duty and obligation on the part of the court, Your Honor, to respect the intent as carried out by as expressed by the Constitutional Commission, and that's
But
very
if it is
clear.
squarely raised, then so be it. Then we will have to take the vote as our conscience will guide us in terms of reading the particular law. May I go to another technical point, just so we're clear. In courts of law, how are facts established? In courts of law, how are facts established? Because I was bothered by your answers to Justice Del Castillo. In courts of law, how are facts established?
They are presented before the courts, Your Honor, and proven
By evidence.
by evidence, Your
Do
Honor.
we have facts? Can the Supreme Court receive evidence?
Factual evidence, no, Your Honor.
We cannot.
Yes,
And
yes, Your
therefore, we
Honor.
are now operating without facts. Is that not correct?
Insofar as the records of the Constitutional Commission, I would think that the court could take judicial notice of the records of the Constitutional
Let's go to
Commission.
that. When can a court take judicial notice? As per our rules. I'm sorry that I have to go back to our rules because I am always reminded to restrain myself with respect to my own personal and political opinions and make sure that whatever we do has to have the precedent of rule, law, or jurisprudence. So going back, how does the court take judicial notice? Or maybe to be more pointed and so that we will abbreviate this. can we take judicial notice that a condom is an abortifacient?
Well, if the court can take judicial notice of all the medical journals that have been written about condoms and hormonal contraceptives and other reproductive products and supplies, family planning products and supplies, Your Honor, then if the court is really interested in deciding on this very important issue, a transcendental issue of paramount importance, Your Honor, then I would like to request that the court could take judicial notice.
Some of us did, and it is robust on both sides. In other words, there are findings of this and that depending on the causality that is put forward, the method of sampling that was used, the name of the scientist that did the study. It is robust on both sides. Would you say that because of the ambivalence of the material out there, that still we can take judicial notice that a condom is abortifacient, or an IUD, or maybe some other hormonal contraceptive is an abortifacient? If Your Honors have read all of these medical journals, then Your Honors must have taken from these medical journals about the risks that the hormonal contraceptives, probably not really the condom, but the other hormonal contraceptives pose to the fertilized ovum. I'm sorry, I may have been mistaken. It may have been a misimpression. But I follow the debates, looking at the websites of almost every organization here, and follow the technical studies of both sides. And they are robust on both ends. My point being, if we are to take a factual position on a particular issue, such as when we say that all contraceptives are abortifacents, it may be, don't you think it may be irresponsible on our part?
If Your Honor, please, if you look at Section 9, there's in fact an admission that these hormonal contraceptives are indeed abortifacient and can in fact be used as abortifacient, Your Honor.
Yes, so, in fact, the law seems to assume that anything can be an abortifacient. Anything. And therefore, it is the use sometimes. And therefore, there is guidance from the FDA. Is that not correct? Is my reading wrong?
If Your Honor, please, just the first point. I don't think it's anything. Section 9 refers to hormonal contraceptives, intrauterine devices, and injectables.
Miscarriages of pregnancy can happen because of many causes. Is that not correct?
Yes, Your Honor. And the implantation taking of contraceptives is one of them, Your Honor.
The implantation of the fertilized ovum cannot succeed due to many causes. Is that not correct?
It could. There are so many causes, and one of them is taking contraceptives, Your Honor.
But my confusion now is, which contraceptive are we talking about? Are we going to ban all contraceptives? Can we do that as the Supreme Court? Still being faithful to the doctrine that we are not a political organ that vetoes another political organ. We are a court of law that reads whatever is produced and looks at the facts and determines whether the facts and the law are harmonious with each other, and therefore we bring in the consequences brought by the law.
If Your Honor, please, we came here questioning the constitutionality of RH law. So, and we have not asked this honorable court to go through each of the contraceptive and say it's abortifacient. So
maybe
it's the law itself that we're questioning, Your Honor,
which part,
because of violation of the constitutional right of the
Maybe let's focus on a particular law. Maybe it's not when life begins that is in question. Maybe it is Section 4, subparagraph A. And in Section 4, subparagraph A, it says, it defines an abortifacient. And again, I beg your indulgence if you follow me a little. I think there are two parts. The first one is the abortion or destruction of a fetus inside the mother's womb. I think there is no controversy there. But there is a second part, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination of the FDA. Is that not correct?
Yes, I read that. It's
focusing on the second part. If the fertilized ovum is destroyed before implantation, can it be implanted? If the fertilized ovum is destroyed before it is implanted,
No, Your Honor. If it's destroyed, it cannot be implanted anymore.
And therefore, any medicine service that destroys the fertilized ovum is prohibited by this law because it is defined as an abortifacient. Would you not agree with me?
Yes, Your Honor. But then there's an IRR that changes this, Your Honor. The IRR changes this definition of the abortifacient,
Which
Your
brings me to another point. Did you plead the implementing rules and regulations?
No, Your Honor.
And therefore,
we did not. But
also a second point, if the implementing rules and regulations are contrary to a statute which governs,
the statute, of course, Your Honor.
do we declare a law as unconstitutional simply because the IRR is not correct in terms of its interpretation?
I
of the
am
statute?
just pointing that out, Your Honor, to show that, what is really the legislative intent for coming up, for enacting this kind of law, Your Honor.
Yes. Let me go to another point which was also covered in your advisory, and this is on the matter of a status quo ante order.
Yes, Your Honor.
Counsel, can you remind us, just to recall, what are the requirements for a status quo ante order?
There's a right violation of that right.
That's a TRO. But for a
and-
status quo ante order, you would agree with me that a status quo ante order is different from a TRO. Is that not correct?
Yes, Your Honor.
Yes. And again, you also agree with me that there is a presumption of constitutionality of a law. Is that not correct?
Yes, Your Honor.
Therefore, in order to ask for the extension of a status quo ante order, perhaps you could remind us of what are the requirements and whether we have passed scrutiny with respect to those requirements. Can you humor us with respect to that?
Well, and Your Honor, I think the existence of a right prima facie and the violation of that right, and if that right is, and if that the violation is not restrained, then it's going to cause irreparable injury, Your Honor.
Maybe just for this time, can you give me jurisprudence to support the definition of a status quo ante order?
If Your Honor, please, in the status, in the
I mean, not a TRO. What we
Yes,
issued
Your Honor.
was a status quo ante order.
that's in the concurring opinion of Justice Brion, Your Honor.
Which mentioned the instances where we issued the status quo ante order,
Yes,
but
Your
did not enumerate the elements. But nonetheless, may I
He
ask...
enumerated there,
Yes,
Your Honor.
may I ask that this be properly covered by both the respondents and the petitioner, because in my mind, and I may be wrong, there is a difference between a TRO and a status quo ante order. And if we are too liberal with the status quo ante order, we undermine the presumption of constitutionality. Counsel, why do we have that presumption of constitutionality again in the first place, may I ask?
Well, we have to presume that official acts have been done legally and properly, Your Honor.
Is it not because we know that the senators and the members of the House and the President of the Republic can as well read the Constitution? And that in our constitutional order, we may have the final say, we may have that finality, but we do not have a monopoly of reading the Constitution. Is that not correct?
Well, it's also my hope that our senators and congressmen know how to read the Constitution. But we have posed our hope, Your Honor, before this honorable tribunal to have the final say on what the Constitution says, Your Honor.
And therefore, if in these cases we will say that it's not yet justiciable, that there should be a case, perhaps a contraceptive going through the FDA, and a finding that it is not an abortifacient, but then you would want to question it, then we can zero in on that particular fact and therefore limit the power of this court. You see, it may be possible that these 15 petitions are making us a super agency, a super department of this constitutional order, which of course, by the history of this court, we do exercise judicial restraint in that regard. My point is, if these cases are dismissed on the ground that there are still no actual facts and we would rather wait for it, is there anything wrong with that?
Yes, Your Honor. This honorable court in North Cotabato versus Government of the Republic of the Philippines, also in Pimentel versus Aguirre have said that a mere enactment of the law is sufficient act for the court to consider it as a justiciable question.
Is that
And
the
if-
latest case, Counsel? Or
Pardon?
is the latest case Southern Hemisphere, which did again go back and back to the original ruling that facial challenges can only be allowed for void for vagueness as well as in relation to freedom of expression? This is by, I think, Justice Carpio Morales, if I'm not mistaken.
I think this is the latest insofar as actual case or controversy is concerned, Your Honor. Especially if, in this case, a primordial right is involved, then if there's an allegation of a serious violation of the Constitution, then I think, if Your Honor please, this court doesn't only have the inherent right, but the inherent duty to look into the alleged serious breach and ensure that the Constitution is upheld at all times, Your Honor.
Thank you, Counsel. I think I've taken too much time. May I just ask one more question? What is so wrong about making all this available to the public and allowing our families, our churches, our faiths to give advice as to whether this menu of options should be taken or not? Why are we patronizing in terms of our citizens? Wouldn't we be more patronizing if we tell the state not to provide a particular option, so that the choices of our citizens are limited?
If Your Honor please, this is not really a matter of, of making choices. This is a matter of preserving and protecting the life of the unborn from the very moment it exists, Your Honor. So this is not about choices. This is not about choices of women or of families, Your Honor. So this is about protecting the life of the unborn from the very moment it exists.
I join you in the protection of the life of the unborn, but my question was, here is a law that simply says that government should provide the information to all that these are available. But it did not say, in fact, there is a guarantee that people are not forced to take the options that are given simply because there are options. May I know what is fundamentally constitutionally wrong with that?
If Your Honor please, again, about the matter of, informing the people what the options are. I think there's a failure of informed consent here because, look, all of this, the adverse effects of contraceptives and the abortive character of contraceptives, these are not, these are not discussed openly. In fact, they're denied by the other side, Your Honor. So there's no accurate, proper information that's given out by Your Honor. It's just you provide, you disseminate widely, and there's really no choice here because effectively the government has made a choice for the people, Your Honor, with all the billions being spent
I'm
to
sorry, but
implement this.
I think the law did not say which of the contraceptives are allowed immediately. It did provide for a process going through the FDA and then a listing in the formulary, and that is, of course, very transparent. I think if you go to the website of the DOH, if I'm not mistaken, you can have a listing right there and then. And to get into that list, of course, goes through a procedure provided by the rules and regulation.
Well,
So in other words, it is not as if government is sinister enough or some part of government is sinister enough to produce it. Don't you think that there is failure of informed consent? If someone is not presented 10 options, but is limited to only 2.
but if you do not give the pros and cons for each option, then I think that's a serious failure of consent, Your Honor.
And there is freedom of expression in the sense that there is nothing in the law which prevents your organization to come out with the studies, maybe the RAND study, maybe the study by the Nobel Prize winner, stating that condoms increase promiscuity, etc., etc. There is nothing. Is there anything in the law that prevents that?
Nothing in the law, but it is also the state that has to give that information, and it's not doing that. The DOH is keeping that information from the public, Your Honor.
What particular act is it pleaded in your pleading the particular act of the DOH that said that.
The abortive character of contraceptives that's being denied, Your Honor. I mean, it's been written about extensively. There are medical journals that's been that are there, that are available, and that's still being denied, Your Honor. Whereas if people are informed about the abortive nature, then people will decide based on their value systems and based on their convictions or religion, whether or not to avail of this particular contraceptive. But that's not being done. And that's precisely why we're here, Your Honor, because there's a continuous denial on the part of the respondents about the abortive character of contraceptives, Your Honor. So people are not informed.
Thank
so
you.
there's no proper choice, Your Honor.
Thank you.